we'll see what we can do. So just bear with me. All right, so we're talking now about, James did a phenomenal job of walking through some ADA considerations. So let's talk a little bit now about long COVID as a disability. When we first had this COVID stuff kind of introduced into our world, I think we were most focused on, how do we handle furlough issues, leave issues, how long is COVID going to be around? What are courts going to say? And I think we pretty much knew where they were going to land, but on whether or not COVID was a disability. And we thought by now COVID would be behind us. But not only is not COVID behind us, but now you've got the issue of post-COVID conditions that employees are now dealing with. So as explained by the CDC, although most COVID sufferers recover within weeks, you have a good population of folks that continue to experience post-COVID conditions. And they define post-COVID conditions as a wide range of new, returning, or ongoing health problems that people can experience 4 or more weeks after first being infected with the virus. And what's interesting about this that the CDC noticed is that even for sufferers who initially, when they were diagnosed with COVID, were asymptomatic, they too can develop the post-COVID conditions. In this arena, there have been different words used to define this long COVID from, you'll hear about long haulers or long haul COVID, post-acute COVID-19, long-term effects of COVID, or chronic COVID. Whatever it's called, we're talking about the same thing, the ongoing lingering effects of COVID and how it's impacting workers. We talked a little bit already about what long COVID is, but here's a definition that the CDC put out. And I think that's a definition that you'll see flows through with other agencies that are looking at this issue. Some of the symptoms of long COVID that have been reportedly aggravated when folks are engaging in physical or mental activity include, but certainly are not exhaustive, tiredness and fatigue, difficulty thinking and concentrating, known as the brain fog, shortness of breath, headaches, dizziness, heart palpitations, chest pains, coughing, joint and muscle pain, depression and anxiety, fever, loss of taste and smell. The other thing, and probably of more concern, is that some individuals are reporting experiencing multi-organ effects or even autoimmune conditions, which can last over a longer period of time. So you're talking about the heart, the kidney, skin, brain functions are being impacted. And when you talk about autoimmune condition, those can cause inflammation or painful swelling or tissue damage that can affect multiple parts of the body. How long do these symptoms occur? I guess here is the lawyer answer. It depends. I think for as much as we've just been learning about COVID as we go, we being the medical professionals, consumers, employers, workers, it's just unknown right now. And so as you'll see later in the presentation, when you're evaluating as an employer, what accommodation to provide a worker, it really has to be an individualized inquiry because of this very fact. And I think even on the worker side, for those practitioners who practice plaintiff side work, from one plaintiff to another, how this COVID-19 long-term affects them, really, it could be different. The proof is in the pudding. I looked out there just to see if I can get some solid numbers. And I was going to try and do a poll today to just see amongst us how many people, either whether it's someone in your family, you yourself, clients, employees of clients, how many people do you know are experiencing long COVID symptoms? And the most recent survey that I found that came out in March estimated that more than 1 in 4 COVID sufferers develop long COVID symptoms. That's a pretty significant population. And again, even those who've had mild cases of COVID could still suffer long-term effects of COVID. So, of course, we're not medical professionals. Of course, it begs the question, why do we care as employment lawyers regarding long COVID? And much like what we've seen right now with the mandatory vaccination, the Biden administration is particularly keyed in on the long-term effects of COVID. And as a result, employers have to consider whether or not employees who are reporting that they have mental or physical impairments after having COVID, whether or not they qualify as disabled under the ADA. And in fact, the administration has recently announced that they intend to protect workers under the ADA regarding those lingering COVID symptoms. And this point was echoed as well by the words that President Biden announced on July 26, which happened to be the 31st anniversary of the ADA's passage. I think what's not stated but clear here and is reflected in other guidance is the Biden administration is not taking the position that hands down in every case, when you're presented with a scenario when someone has long COVID, it in fact will be a disability under the ADA. Instead, it is clear that there is a push, if you will, to put things in place to ensure that if there is someone who is suffering from those long-term effects, that there is some protection for those individuals. And we'll talk more about that in a moment. Further echoing that is the Assistant Attorney General, who said that they will vigorously enforce those laws that are intended to ensure that those folks who are impacted by COVID are full and equal partners in that recovery. So what does that look like? Following the Biden announcement, the White House did two things. They put out a fact sheet and they put out a joint guidance. What's interesting about the joint guidance is if you read the quote there from Biden, it was intended to be a joint effort, if you will, by the federal agencies that have interest in this topic and stating kind of what the position of the federal government is with respect to long COVID. What was noticeably missing at the time was a statement from the EEOC. So the joint guidance was just from the U.S. Department of Health and Human Services, their Office of Civil Rights, and the Department of Justice. The fact sheet, which covered more than just long COVID, just really talked about all the different ways in which the federal government was going to support this initiative to ensure that folks dealing with long COVID, in fact, are covered by the ADA. So here's an overview of what the joint guidance provides. It explains what long COVID is and its symptoms, which mirrors what we talked about earlier in the presentation today regarding what the CDC has said. It states that COVID doesn't say it is, can be a disability under the ADA, Section 504 and Section 1557 if it substantially limits one or more major life activities, which is a standard that we've all been familiar with in dealing with issues of disabilities under the ADA. It describes long COVID as a physical or mental impairment, and it identifies ways in which long COVID can substantially limit one or more major life activities. Again, as I stated already, it notes that long COVID is not always a disability. It does, in fact, provide examples of ways in which businesses, state and local government can make changes so that folks who are dealing with long COVID can make those accommodations to help workers who are experiencing limitations as a result of that. And then it has a long list of federal resources available for people with symptoms of long COVID. The guidance, as I alluded to before, really is talking about issues under Title II and Title III of the ADA, but makes clear that it does not address examples of reasonable accommodation or non-discrimination in employment, specifically under Title I of the ADA and Section 501 of the Rehabilitation Act. Instead, the joint guidance simply said, in quote, that employment issues related to COVID are discussed in technical assistance issued by the U.S. Equal Employment Opportunity, and it cites the long ongoing guidance that I'm sure we're all familiar with and we've been following since May of last year, if you will, that the EEOC has been regularly updating regarding various issues concerning COVID and the ADA. However, Just on September 9th, the EEOC woke up and issued a statement saying that the EEOC recognizes that long COVID may be a disability under the ADA in Section 501, and it's explicitly agreed with the analysis by the Department of Health and Human Services and Justice and the joint guidance that we just talked about. Even though the guidance that I'm referring to doesn't specifically address the employment context, this statement by the EEOC makes it clear that that is pretty much the framework that they're going to follow. However, the EEOC has indicated that they will be issuing technical assistance in the employment context in the next couple of weeks. So much like you're following the developments concerning these vaccine mandates, here's another development that practitioners should also be following. So how does COVID fit within the existing ADA statutory scheme? So as it stands, we already know that the disability can mean a physical or mental impairment that substantially limits one or more major life activity. It's an actual disability. It could refer to a record of such impairment or be something regarded as having such an impairment. The guidance that's come out is not intended in any way, as I read it, to change what we've known to be true with respect to the ADA and what needs to be established to fall under any of those prongs, or to establish, in fact, that the condition must, in fact, impact a major life activity. So we're talking about caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, all those things that we've known to be true as to be considered major life activities. Now, sticking with the joint guidance, here are the examples that they've provided as instances where long COVID can in fact be an actual disability. So if you're dealing with a person who has lung damage as a result of having COVID, and as a result, they're substantially limited in respiratory function, that is going to be likely considered an ADA disability. If you have a person that as a result of lingering impact of COVID on their digestive system, such that they're having intestinal pain, if they're experiencing vomiting or nausea, that as well could be considered an actual disability. And then a person with brain fog who is substantially limited in brain function, such as concentrating or thinking, that too will be an actual disability. And interesting enough, I actually sat in on a presentation where a doctor was actually talking about the medical science behind this brain fog, and it's indicated he himself experienced it. And in the middle of talking and doing a presentation that he could probably do in his sleep, he forgot the medical term that he was referring to. And he indicated in that moment that that is something that regularly happens to him and has happened to him for months since he had COVID. And again, this is stuff that he could do in his sleep. So that illustration just shows how, for some people, in fact, COVID can really have some lasting impact on some major life activities. Here's what the joint guidance does not say, and I've already stated it again, but it's worth repeating. It does not say that COVID is always a disability, and in fact, it echoes an individualized assessment remains necessary. So, when you're talking to your clients, whether you're on the worker side or whether you're on the employer side, at the end of the day, the good old interactive process still remains kind of the golden rule, if you will, in how to address these issues, that workers need to participate in that process so that employers have the information they need to assess the accommodation requests when they come up. And on the same instance, an employer should just not assume, because one employee displayed certain symptoms, that in another case that those symptoms impact the employee in the same way. It truly should be based on that employee, that worker's individualized circumstances. Now, in the slide, about 2 slides ago, the reason why there's only illustration of what would be considered an actual disability is because the guidance does not speak to what would be considered record of or regarded as a part of the disability definition. But it does know that certainly that is going to be relevant to the consideration. So if you haven't read that guidance, when you go in and read it, keep in mind that just because the guidance does not refer to those 2 prongs, that it's something that they're not paying attention to. As a result, employers definitely need to, be mindful that there are still those aspects of ADA that certainly come up in the context of long COVID. What are the type of accommodations that long haulers will likely be looking for? Some of the same accommodations I think that you've already been experiencing since COVID came around, whether that's leave, reduced work schedule, jobs restructuring, reassignment to different position, remote work, and there's certainly many others. I think I saw an article recently that attempted to do a compilation of all the different accommodations that businesses have implemented since COVID's put in place, and the number was actually outstanding in terms of how creative and flexible employers have been. So, just it's the same type of considerations that employers have always had to go under. There's no expectation that you have to remove essential job functions, lower production standards, or provide an accommodation that creates an undue hardship on the business. And you also certainly still do not have to provide the preferred accommodation so long as the accommodation is effective. So what can be done? I think everyone, not even with the announcement recently with the Biden-Harris administration, but certainly prior to that, employers certainly saw the writing on the wall that these claims were coming. I think we saw, and we'll talk about some of the litigation that's out there soon, but there was lawsuits filed concerning long COVID claims at least as early as March or May. So this isn't new. So if you haven't already been advising your clients, as to what to do to prepare, here are some suggestions. And I think, this information is worth practitioners who represent workers hearing too, just to know, what's likely on the horizon or what is likely being done in the workplace to address these things. So certainly if it's already hasn't been done, this is always a good time to review your policies and procedures to ensure that you're providing that opportunity to sufficiently address these long COVID claims. You should also thoroughly analyze company, department, employee production and performance levels before, during, and as the pandemic continues to go to determine the feasibility of certain accommodations, such as alternative schedules, that teleworking or other things that we know will likely be requested by employees. Along with reviewing your policies and procedures, it's a good time to look at your accommodation processes to ensure that it's in compliance with the latest guidance that we've been getting concerning COVID-19. Whatever ADA interactive process forms you use, good time to update those and develop COVID-specific and long COVID-specific forms to be completed by the employee's physician. And as we all know, those of us who do defense work, I think there's a consistent message that your managers and supervisors are your front line of defense, right? So it's always a good thing, not just for that purpose, but even for the workers' benefits, that continue to train your managers on the importance of avoiding inappropriate or potentially disability-related inquiries regarding COVID-19, along with protecting confidentiality of information they may receive from employees. Again, it just curtails the likelihood or the risk associated with claims. And then I just think it gives workers the benefits of the processes that workplaces have put in place to assist them. Of course, you always have the ADA sister FMLA that, I won't spend much time here, but, certainly you could have instances where you're dealing with individuals who have long COVID that maybe they don't have a disability that provides them coverage under the ADA, but they may have a serious health condition that may provide them coverage under the FMLA, such that they would require leave. So it's just worth mentioning that in addition to looking at this from an ADA context, that you certainly don't want to forget about FMLA considerations. So again, as I mentioned at the outset, I hope so that this could be interactive. We would have the opportunity to do some polls here, but hopefully there's enough cameras on right now that maybe we can do an informal poll. So maybe just by show of hands, how many people have filed or are defending a claim involving discrimination or failure to accommodate related to post-COVID symptoms? I unfortunately can't see your hands, but hopefully your fellow practitioners can see them. Just so in our bunch that I think we're at 270 participants, we can get a sense of kind of the trend that we're seeing related to these issues. So since we're here, let's go ahead and talk about some of the lawsuits that are already out there. So one that was filed in June of this year is Edelman versus Aristocat Plastic Surgery. It actually was brought by a GC of APS who alleged that the company wrongly furloughed him while he was hospitalized for COVID and then refused to rehire him due to his long-term virus symptoms. My recollection of the case is that he did not mention in his complaint specifically what accommodations or that he in fact had made requests for accommodations, but he certainly alleged that it was his belief that APS failed to engage in any form of an interactive process to discuss possible accommodations that might have allowed him to return to work. It was his position that because of that, they failed to provide him a reasonable accommodation and then took an adverse employment action against him because they regarded him as being disabled. What's interesting about this and this case and the next case that I'm going to highlight is, of course, it's still early in the process such that, you know, unfortunately for purposes of today's presentation, I can't give you a preview as to where the court is going with any of this, but APS recently sought leave to file a motion to dismiss. And the basis of the motion is that they claim that no one in the world understood COVID at the time to be anything more than a transitory, albeit serious illness. So from APS's position, there would have been no reason to provide reasonable accommodation to this gentleman at the time. There's a pre-hearing conference set on October 14th, so we'll see how that develops. So that's certainly a case to watch. Another one that was filed earlier in the year in March. This one was actually filed in California and is actually a claim arising under California state law, which is modeled after the ADA. An employee claimed that she contracted COVID. She was placed on medical leave. She then had symptoms and was considered a long-haul COVID-19 patient. She requested allegedly additional leave, and according to her, was told by her supervisor that you better not request that additional leave. As a result of that, she claimed that she did not seek medical leave and then consequently began to experience absences from work. And she acquired so many leave points or absent points that she was terminated consistent with the employer's attendance policy. So again, here's another case to just watch to see how these long haul symptom cases are being handled in the court system. And, you know, our firm does it. I know other firms do it as well. You know, we are constantly tracking all the COVID litigation, and without fail, the top issues in terms of litigation right now in the COVID perspective end up being around accommodations, the remote work leave, that type of thing. So for sure, I know we'll have some cases coming out of the courts related to these issues. So before we wrap up here and open it up for questions, which we thank you for your patience. I know you've had some questions, but we wanted to make sure we got to the content before we answered any questions. But, you know, here are some key takeaways. I mean, you know, it's a really easy, straightforward concept in theory, but we know anytime we're talking about ADA disabilities, there's always things that require additional consideration. So, you know, at the end of the day, whether you're on the plaintiff side or the defense side, the inquiry doesn't stop at whether or not COVID-19 is a disability, right? That there are certainly impacts of COVID-19 on an individual that should be considered in determining what rights employees have and what responsibilities employers have to those employees when those employees come forward requesting certain accommodations as a result of those post-acute symptoms that they're continuing to experience. As we've stated throughout our presentation today, this is yet another developing area in our labor and employment practice. So you certainly should continue to monitor litigation. Certainly it's bound to increase. As shown earlier today, EEOC technical assistant is on the way. But for what it's worth, that joint guidance again gives a significant clue as to what practitioners can expect. And I just want to echo again that interactive process is just, kind of a necessary evil when you're talking about how to address these long COVID symptoms that employees are impacting. So with that, Yvette, I'll turn it over to you if you want to open the floor for any questions.
Absolutely.